Hello and good morning, everybody. Mark, good morning to you, sir. How are you?
Good morning, Lee. I'm very good, thank you. How are you?
I'm very good indeed. A little bit upset. It's the last webinar of the year, but what a better way to go out than with you guys from Way Trustees, eh?
Yeah, got to go out with a bang.
Go out with a bang, absolutely. We've had a really good sign up for this webinar. As always, with you guys, I think you cover off some really good hot topics. Um, Conscious that you've got loads of content to get through today, so I will literally just give it another 30 seconds before we kick things off. But I hope everybody has had a great year. I know a lot of people are winding down sort of tomorrow and taking things easy next week, probably just more reactive than proactive within their business. Um, Much time that we all need to recharge, re-energize, and come back fighting in the new year. It's gone so quick, Mark, hasn't it?
It's flown by, really. It's been relentless, if I'm honest. It'd be nice to think that we'll get a little bit of slack between
Yeah.
now and the new year. So hopefully, if that can happen. But yeah, it's been a remarkable year in terms of activity and engagement, and we've been flat out for a long time. So it's all good.
It's all good. It is all good indeed. So, as always, good morning to everybody. Thank you again for coming along to the Financial Planning Club's webinar, which is normally held on a Friday, but this week we've moved it forward to a Thursday. We are all out celebrating tomorrow. So, thank you all for accommodating and joining us on a Thursday morning. We do plan for the webinar to run for the 4 hours, so please do make most of the time with us and ask as many questions as you'd like. Mark is going to focus on the content. We've got John in the background that's going to be answering any questions, so you can either ask some questions in the chat function, or there's a Q&A section as well if you'd like to send them direct. So please do make most of your time with the guys today and ask any questions that you'd like answering. We do, as usual, have a couple of polls that we'll be running throughout as well. So please do participate. It's always good to hear from the audience. Feedback is so important to us. So when the webinar does end and you leave the webinar, there'll be a little feedback form that pops up. Please do participate. We'd love to hear how you thought the session went. There'll also be an opportunity for you to interact with the guys over at Way Trustees, as you can do with us at the club as well. So with that being said, let's kick things off. And I'm just going to give you a high level summary of everything today because I know we're going to be busy. The membership experience for business owners at the Financial Planning Club, everything we do is based on the structure of your business. It's about giving you that guidance, that clarity, and the accountability to make everything within your business completely possible. You could be looking at growth, operations, tech, people, culture. Either way, we are here to help your business thrive in today's industry, which is amazing. Some use us as a non-exec direct, some use us as an agony aunt, but we are here to support you. I don't know if you've seen what we've been running recently, but we are also kicking off Experience the Club from January. This is a 6-week program fully funded by Tatton Investment Management. Our friends over at Tatton, they're amazing and they're very supportive of what we do at the club. It is for financial planning firms who want more clarity, structure, and momentum as we kick off 2026. So our first cohort ran in November into early December, and the feedback was absolutely fantastic, with firms gaining stronger focus and practical systems that they could implement straight away. So it's a 6-week program. They're weekly 90-minute sessions. I believe we kick these off on a Monday. I think it's 12:30 till 2. So please do drop us your details on the feedback form if you would like to hear more about Experience the Club. So we're creating a clear one-sentence vision, building structure so that the business doesn't rely on you, track the numbers, fix recurring issues, spark natural, consistent referrals, and turn ideas into a realistic 90-day plan. So again, big thank you to Tatton Investment Management to fully fund this cohort and give you guys an opportunity to really experience the club as well. This starts on the 12th of January and it runs through until the 16th of February. Aside from what we do for all of the business owners of financial planning firms, we like to build a community that works for everybody. Some of you may well have come from our WhatsApp groups that's absolutely buzzing, especially around budget updates and budget times. The Power Planner group goes absolutely insane. There's over 500 Power Planners in the Power Planner group, 300 advisors in the advisor group, and the business owners. So we've got separate groups depending on the role that you play within your business. As you know, you're here with us today. Our webinars are expert-led, practical, and CPD accredited. After today's webinar, you will receive an email to fill in your details to get your CPD certificate. You'll also get a copy of the recording as well, so you can revisit and cover off anything that you might have missed. Our face-to-face events have come to an end this year, but we're going bigger and better next year, so keep an eye out for any of our face-to-face events where we bring the club to you in person and we go through some real in-depth strategy sessions. Our podcast is on demand. It's growing arms and legs. I can't even tell you how many episodes we've recorded now. But if you want to hear from business owners that have gone through the highs and lows of running a financial planning and setting up a financial planning business, please do tune into our podcast. And I think that's available on all of your normal platforms. And our CEO roundtables as well. It's high-level discussions for decision makers within the business. And we run those every single quarter as well. So that's a bit of something for everybody. Catch your breath. I'm nearly there, guys. We've got a couple of webinars coming up in the new year. We're going to kick things off on Friday, back to Fridays on the 16th of January. So we're joined by Albion Strategic Consulting for keeping your investment proposition world class. So this session is all about strengthening your CIP. Then on Thursday, the 22nd of January, we are with FE Fund Info, and we're returning with tech, trust, and transition. So this is all about the age of AI as well. So it's a massive talking point in our industry. Some people are fully integrated. Some people are just toying with it at the moment. But come along to our webinar with FE Fund Info if you want to have a little bit more of an insight into the world of AI. Just a quick shout out to all of our collaborators. We couldn't do what we do without the incredible support of every one of our collaborators. Each and every one of these businesses play a key role in helping our members navigate change and unlock new opportunities. They really do share a commitment to driving the profession forward with their expertise, their innovation, and their genuine desire to make a difference. That's from technology to recruitment to training, marketing, proposition building, whatever it may be. We have a collaborator that can support you and your business. So again, another massive shout out to all of the collaborators working with the club. This brings us on to today's session. So joining us from Way Trustees is Mark, Business Development Manager for the South. There's a fine line where you draw a line and you're not going any higher, Mark. That's right, isn't it? When you say South, where are you not allowed to go above?
Well, when we get to the middle around Birmingham, John and I have a discussion about where we will look after really. But generally, I look after everything south of Birmingham, and John looks after everything north. But there is a little bit of crossover in the Midlands there. But that's broadly how we operate. So
if you're in Birmingham and you get either one of the guys, just know it was down to rock, paper, scissors as to who you got, Mark or John.
It's a lucky dip.
It's a lucky dip, but we've got a real good mix of attendees today, mostly as expected, financial planners and advisors with a broad spread of experience across estate planning and tax planning as well. What's interesting is half the advisors told us that they're already recommending loan trusts, which is great, while others said they're holding back for now due to complexity or suitability. It was an interesting set of questions that we asked the attendees, Mark, and the responses. How are you seeing the industry as a whole at the moment? Is it quite optimistic, or are people a little bit hesitant around the loan trust side of things?
See a bit of both, really. I mean, we've seen some significant change, and some of that we'll get into in the presentation as we go forward. Some advisors want a little bit more clarity and certainty from the legislation before they actually move forward with how they might advise clients. So we're seeing some that are happy to crack on. I mean, I've always said to advisors and any on the call today that have dealt with me, we can only use the legislation that we got before us today. So that's we know the general direction of IHT is not getting any better. So there's some merit in considering the legislation we've got today. moving forward. But I appreciate we have to have one eye on what could happen in the future. I mean, you can't plan for unknowns.
No.
So, now that we've got both of those budgets out the way, we do have a little bit more clarity going forward. Yes, we're still going to see some changes, but all we can do is work with what we've got today. And that's generally my advice to advisors. And then they make a judgment call themselves as to how they might take things forward. These changes, of course, do bring complexity. And that's where John and I are very busy engaging and discussing matters with advisors across the country on how certain things might work, what our thoughts are, etc. So there's a real mix across the industry at the moment, and of course, uncertainty that's created by the political classes is not always helpful or wanted, really. But that's often what we get.
Yeah, absolutely. Well, look, let's kick things off. I will stop sharing my screen so you can share your screen. Again, as mentioned, if anybody's got any questions throughout, I know there's some things going in the chat at the moment. So if you've got any questions, please do fire them in. John is here on hand to answer them as we go along. If there's time towards the end as well, we will go into a bit of a Q&A session if you want to talk to the guys directly. So enjoy this today's session, guys.
Okay, thank you, Neve. Thank you for the introduction. Good morning, everybody. I'm Mark from IHT Trustees, and we've got quite a bit to get through today in around about 50 minutes. So I promised to get through it on time. And hopefully, if you do have questions, as Lee said, my colleague John's on the chat facility on the Q&A, and hopefully they can help you out as we go along. So today on the agenda, we've got a budget update. We're just going to focus on the bits, obviously, that we're talking about today, so estate planning, IHT, that type of thing. We'll then dive into what does good estate planning look like. I know we talk a lot about consumer duty, and perhaps the advisors on the call perhaps had enough of it, but we'll just take a look at consumer duty in this particular area and the elephant in the room and how we might address that going forward. And then we'll try and pull all that together with a multiple trust framework to show you how the consumer duty principles in action actually work. So the learning objectives today, hopefully, will be to incorporate these budget changes into your planning on a regular basis, understand the framework behind good estate planning, integrate those consumer duty principles, and hopefully understand how multiple trust frameworks can strengthen your recommendations. I genuinely do believe that the days of only recommending one type of trust are gone. I think we need to move on from that. And we will touch on loan trust today. Okay. So budget 24, we'll start with that. The three main changes there, really, they were quite significant. Of course, we've got this change to the BR and APR from 6th of April. There's going to be a £1 million cap on the 100% relief. Assets above that will only attract 50% relief, so that's a significant change. The AIM market, again, will only benefit from 50% relief going forward, and pensions from April 27 are going to be brought into account for IHT. And each of those are really quite significant changes that were announced in that budget. And we're still trying to, unpick certain elements and make sense of, how the pensions thing is going to work, for example. Then we came to budget 25, and I was in London at the time and took the opportunity to listen to the Chancellor's speech. And at the end of it, I felt, there was certainly no further grenades that we saw from budget 24, and it felt initially light to touch, which was a good thing, really. But then when you get down into the detail, I think there's something like 90 changes to the tax code in that budget. And I think that's driven out of the fact that they didn't want to go against their manifesto commitment. So they didn't want to attack the obvious and, the big ticket items. But it did mean, of course, they had to tinker with everything else in order to raise the money that they need to fulfill the plans that they want to deliver. So if we have a look at budget 25, one of the positives that come out of it was this unused allowance for BR and APR reliefs is now going to be transferable, which is a positive for those who are going to rely on that relief. Although it's going to be transferable, as we'll see later in the presentation, in many instances, I think we shouldn't rely on the fact that it's transferable. We had some change to dividends, income tax on dividends, just going up 2 percentage points. So we'll have basic rate at 10 3/4 and higher rate at 35.75. There was no change to the additional rate. That remains the same. So I expect we'll see some business owners here perhaps pulling forward their dividends to take advantage of those lower rates. Doesn't really impact the additional rate taxpayers. And it's also expected that the 2% additional income tax rates will apply to trust income. So that will move discretionary trust income up to 47%, and on interest in possessions like wage trusts to 22%. IHT treatment on unused pension funds is clear now that they are going to go ahead with that. Initially, of course, they were trying to get the PRs and the pension scheme administrators to take responsibility for the inheritance tax. They've now moved that back to the personal representatives, but they have listened to some of the feedback that they've been getting, because it was highly undesirable for personal representatives to take on these roles now. So what we saw in the budget was that there's provision now for those PRs to direct pension scheme administrators to withhold up to 50% of taxable benefits for up to 15 months, and in some circumstances pay the IHT due. Now, I think the general feeling within the industry is that 15 months isn't long enough. We know what probate's like, etc. Okay. And importantly, they will be discharged from their liability for the payment of inheritance tax on pensions once they've had clearance from HMRC. So that's a positive for them, because it was quite unattractive otherwise. Although I think the illiquid assets within pensions is still a problem going forward. The IHT thresholds, they're frozen out to April 2031. And it's interesting to look at the average house price in 2009 was around 226,000. In 2024, it was 334,000. Now, those figures vary depending on which source you look at, but it's estimated that an extra £4,500 estates are likely to be caught by 2031. And of course, they've pushed out the personal allowances on income tax as well to 2031. It's estimated that just under 5 million of people will now be drawn into tax when previously they weren't paying tax, and consequently an equal number is likely to be pushed into the higher rate band as well. Inflected blood scheme compensations, we know they're exempt from IHT. There was some further provision in the budget to make sure that those who were infected or affected by that blood issue, that died before receiving compensation, means that the first living recipient of this compensation payments will still benefit from that, effectively an IHT credit on it, and they've got a 2-year window in which they can gift on that compensation benefit and get an IHT exemption. And of course, then we had the mansion tax, or what's called as high value council tax surcharge in the legislation. That'll kick in from April 28, and it'll be based on 2026 property values. So maybe good news for surveyors here. It will be administered via the council tax system and expected to raise around about £430 million per year. Now, the money that's being raised off the back of this isn't going to your local government, it's going to central government. But it does beg the question if we'll see further reform here in the council tax system more generally. And these are the tapers. So once you've got a property above £2 million, there's going to be this new surcharge. Starts at 2,500, and again for the houses over 5 million, it'll be 7,500. Now I suspect there'll be some collateral damage, if you like, here, because through no fault of some families, that where they live and the family home has been in the family for many years, they're not necessarily, wouldn't regard themselves as wealthy individuals, but now might be faced with this tax surcharge. Now, given we are close to April 26 and the changes that are going to be brought forward for business relief, I thought it'd be useful to take a closer look and just put a few things on the radar for advisors, specifically with the changes to BR and trusts. So the key date, as we know, is the 30th of October 24. And the key questions for advisors now really should be along the lines of what type of trust do you have? When was it created? And therefore, what rules apply? Because what we've been left with here is a set of legislation prior to that budget date. We've got a new set of legislation that follows it, and an interim set of legislation as well. And multiple parts of that might come into play depending on what we're dealing with. So if we take qualifying interest in possession trust as an example, as a type of trust. So a person who's got a qualifying interest in possession trust is treated as owning the underlying assets, as we know. Now, these are included in their estate on death, rather than being subject to the ongoing exit and 10-year charges. And such an interest is charged typically up to 40%. Now, any business relief qualifying assets held in that qualifying interest in possession trust will be included, therefore, in the deceased estate on their death. So the £1 million will apply to deaths on or after the 6th of April 26. So the 100% relief is referable in this case to the person, not to that of the trustees of the qualifying interest in possession. So we'll have the personal assets, we'll have the life interest assets. They'll be added together for the purpose of the new regime after the 6th of April. Okay. So there's some practical considerations here. Again, I mean, advisors might have this situation. What happens on death of the life tenant? What's the IHT position on it? How will it split between the life interest assets and the personal assets? And how does the tax get paid? On relevant property trusts, again, the key date is the 30th of October 24, which was budget day. The question is, at the time of the budget, did the trust have any relievable assets in them or relief at 100%? If the answer is yes, the trust gets £1 million allowance for BR. If no, there's no automatic allowance, but the trust can acquire the allowance through other means. So again, practical considerations in this area. For the trusts that were settled pre-30th of October 24, the new rules will apply to the first 10-year anniversary after April 26. Okay. Now, if you've got a periodic charge that falls due between now and April 26, then old rules for exit charges will apply until the first periodic charge that falls after April 26. So that's quite useful for those trusts that fall in this time period because, of course, we're playing by old rules effectively at the moment, which means that if your trust does hold qualifying assets, it could be fully relieved to zero and set the exit rate for the trust at zero as well. So that's quite a handy bonus for trusts that fall in that particular area. For relevant property trusts that were established on or after the 30th of April, we got slightly different rules here. So they will have a limited allowance, and that allowance will be shared with other trusts that have been settled. There is a window of opportunity again here. So up until April 26, the old rules will apply to transfers into trust. So as long as those reliefs apply as intended, the full value will be relieved to zero. There'll be no IHT, lifetime IHT charge. And the new rules will only bite on the periodic charge in 10 years' time. Now, that can help with residence nil rate planning, as we know, because the asset test there is who owns the asset. And if you transferred business relief qualifying assets to trust, it's the trustees, not the individual. There's a couple of points to note in this area, though. There is anti-forestalling rules in position whereby the donor makes a lifetime transfer of business relief qualifying assets on or after the 30th of October, but dies within the 7-year period after the 6th of April 26. Okay. So as we know, when you gift business relief qualifying assets into trust, it is a gift. If the donor dies within 7 years, those assets are retested on death. Now, if those assets remain qualifying at the point of death, it will be relieved to zero in the estate of the deceased. Okay, where that death now occurs within 7 years, but after the 6th of April, we're playing by new rules, and that trust will only have £1 million worth of allowance to work with. So you might have settled 2 million into trust today, had it fully relieved to zero. The client then dies December 26. Okay. It'll be retested on the new rules. So now we've got 2 million in the trust of BR qualifying. Only 1 million will be relieved at 100%, the other million at 50%. Okay, so that's a slightly different set of rules there in this particular instance. Now, how distributions from trusts are treated rely on two different bits of legislation here. We've got Section 68 for distributions of capital before the first 10th anniversary. And then we've had, up until recently, Section 69, which deals with distributions of settled property made following a 10th year anniversary. Okay. Now, where that 10th year anniversary arises on or after the 6th of April, the BR and APR will no longer be taken into account when calculating the IHT rate for the trust. So that's quite a big change here. So in future, it will be based on the unrelieved value of the trust property for all exit charges, whether they are before or after the first 10th year anniversary. So there's quite a change there. It's all about tax grab at the end of the day. Obviously, it's far less attractive now. And historically, of course, we would encourage perhaps clients to hold BR over the 7th anniversary, because there's a risk if they die and you've changed the BR into something that's, not exempt, then it's unrelieved in the estate of the deceased, and perhaps a less favourable tax outcome. And of course, it would often be wise to perhaps hold those assets over the 10th anniversary, because the old rule said that we can take into account BR assets, get them fully relieved to zero for the purpose of the periodic charge, and importantly, set the exit rate for the next 10 years at zero. That's the bit that's changing now, where that periodic charge falls after the 6th of April. And one minor point, again, it's all about optimizing the tax planning. You might be considering putting BR assets into trust for a client for all the benefits that that provides us. You might also be considering to do some, perhaps up to their nil rate band into trust as a chargeable lifetime transfer at zero. Now, the process for two of those are quite different, and so is the timescale. You might decide, well, I can use, dare I say, the product provider trust, put 325 into that, because that can take a week, maybe 2 weeks, get that settled whilst we sort out setting up the discretionary trust, transferring the assets, claiming the BR relief, etc. Maybe hold over relief on the way in, and that can take some time. So you might think, all right, well, we'll get the 325 into trust today, and 2 or 3 months later, the BR trust has been settled. But that's less favourable for the period of charge planning, because we'll have 325 in account for the first trust, and the figure for the accumulation is 325. And now we've got a later discretionary trust holding the BR assets in. But when it comes to the periodic charge assessment of that discretionary trust, we need to look back for chargeable transfers. We'll see the 325 you did, because that was easier to set up, and it will permanently rob the discretionary trust of its nil rate band. So that's, inefficient. It'll cost perhaps £19,500 of tax paid that might otherwise have been avoided had we given thought about the planning here and said, we need to do the BR trust first, because it will hopefully be relieved to zero. And it's the zero figure here that's the accumulation figure for the later CLT. So that means the BR trust will benefit from its own nil rate band going forward. And then when we get to the CLT that we have put 325 in, it's zero that's accumulating with it. So that gets its nil rate band as well. So it's a minor technical point, but one that's worth £19,500. And from my reading of the budget, that's still an option. And as always, it's a cost-benefit analysis here. The scenery here for putting BR relievable assets into trust is still a valid option. It has changed, and it's just, do the benefits outweigh the costs, really, and that's on a case-by-case basis. This one almost slipped under the radar. Changes to the non-dom regime. So the IHT changes can impact anyone in the right circumstances. That includes trust. And the premise under the old regime, where the IHT for a trust was set at establishment, that no longer applies. So we might have had a non-UK domicile settler with non-UK situated assets. That would generally be out of scope for UK IHT. Conversely, if we had a UK domicile settler, the situs of the assets didn't matter as much. It was in scope for IHT. That all changed on the 6th of April this year. Okay. Now, in most cases, as we know, there's plenty of caveats around tax rules, for example. We no longer look back at the domicile of the settler. We now need to look whether or not the settler is long-term resident. Okay. So long-term resident and tax resident are closely related, but they're not the same. So in most cases, it is possible to be long-term resident. Well, in some cases, you can be long-term resident, but not tax resident. And it is possible to be tax resident, but not long-term resident. In most cases, you become long-term resident once you've been tax resident for 10 years. However, where a client might say, right, I'm up in sticks, I'm going to live elsewhere, there's something that we need to be mindful of. There's a potential sting in the tail here. There's a tax tail. So you will retain your tax residency for a number of years after your departure. How long that tail is depends on how long the individual's been in the UK prior to departure. So for someone like me who's lived here all my life, it's probably going to be 9 or 10 years. So once I've not been tax resident for 9 or 10 years, I will lose that long-term resident status at that point. This is where an exit charge might apply. Okay. And advisors need to be mindful of it, basically. In the original drafting, the clever people spotted that perhaps if at the time the client lost their long-term residence status, the trust was holding UK assets, it would avoid the exit charge. And then, of course, at a point later, you could restructure the trust assets and do something different. I think the government has spotted that one now. So I think whether your trust is holding UK assets or overseas assets, you're going to get potentially caught by this exit charge. So some summary of this session, really, some of the key dates. We've had the domicile test change. April next year, we got the business relief change. April 27, we got the pensions. I think we're going to see some further tweaks to that before it actually comes to pass. And of course, all of these allowances here are nil rate band, residence nil rate band, the taper for residence nil rate band, and the £1 million allowance is frozen out until 2031. Okay. Now, interestingly, in the legislation for the BR and APR £1 million allowance, it requires the government of the day to make an order via a statutory instrument in order to implement that increase. So I guess that's our code for it's probably not going to get increased by CPI. It'll be down to the government of the day. And as always, I'm not a chartered tax advisor. For confirmation on any of this, of course, I'm going to add my own caveat here. That you should obviously take appropriate advice from chartered tax advisors on this. But hopefully that session's been helpful. Okay, we got poll question 1 now, please, Lee.
Poll question number 1. Give you some breathing time. So the first poll that we're going to ask today is: when discussing estate planning with clients, how often are the beneficiaries present in the meeting? I'm more interested in knowing sort of what challenges come up when the beneficiaries aren't involved, and how do advisors really sort of handle that? So do you see a bit of a change from those that have beneficiaries involved and those that don't?
Yeah, I think there's a risk. If you're dealing with mum and dad, wealthy, obviously got an IHT liability, yes, you're going to do good planning. When the children, the next generation, get whiffed of it, they're often naturally, okay, who's dealing with mum and dad? What are they doing? Because unfortunately there's that element of, they're less good people out there that perhaps. So there is a risk at that point, maybe when the kids get involved, it might fall over. So my advice usually to advisors, or suggestion, is to try and involve them at some point. We know this money is transferring over the generations. If we can have a contact with where this money's going, it's often helpful. And if you can involve the children at some point in that process, do the heavy lifting with the parents first, and then, plant the seed that sometime we need to involve the beneficiaries, the children, because it's very important that they understand what's been put in place for mum and dad, and importantly, how it's going to benefit them. And if there is a benefit to them, they think, oh, okay, yeah, I can see where you're going with this. There is a benefit to me. I'm happy for you to continue with mum and dad. So I think it's generally very well, and I'm sure many advisors do this. They do involve, I don't know what the poll's saying, mine. They do involve the next generation at some point, and I think it could be very useful because, when mum and dad pass on, ideally, if you've got a relationship with the next generation, you can also almost future-proof your book of business. Trust money is very sticky money by its nature. So
this is a huge talking point amongst the industry, with what's set to be passed down through generations in wealth. I think it's sort of 5 trillion over the next 20 years, I believe it is. It's going to be passed down through the generations. So every opportunity that you get to bring the beneficiaries into the mix and start building that relationship with those beneficiaries early on, it saves any risk of them already engaging with different advisors through the likes of social media at the moment. It's just, as you said, it's just securing your business long term as well. Poll results are in, and I will share. We had close to 100 people participate in the poll, so thank you very much for everybody that did choose an option. 6% say always, 34% said sometimes, 51% said rarely. So half the audience that participated said they really involved the beneficiaries in estate planning meetings with the clients, and 9% said never get them involved. So I think over half is either rarely or never, which is fairly surprising, right?
Yeah, I thought it would have been a little bit different to that, really.
Yeah.
There's certainly advantages to involving the beneficiaries at an appropriate time in the process, just to make sure they're on board, and importantly, say to them, well, this is why we're doing it. This is how you're going to benefit. maybe an opportunity to gain them as a client if they're not already a client at that point. But more importantly, you've got two generations buying into the same planning here. They understand it. They know the reasons for it. When the time comes, they'll understand what the framework's designed to do. So it's a personal choice. I think, if it was me, I always did try and, when I was advising, involve the next generation at some point. It was important for me that the children knew that we were doing good work for mum and dad and not, doing something that we perhaps shouldn't be. So,
What would you
as I
say would
said,
be the, yeah, absolutely. What would you say would be the right moment to bring in the beneficiaries?
I think obviously you've got to engage the client, come up with a plan, present it to the client, and then if they think, yeah, okay, we're happy to proceed with, an element of the planning that's been recommended or all of it, perhaps. I generally position it up front relatively early on to say, look, we can have a look at how we can help you, and and if it's something that you wanted to go ahead and pursue, then at the appropriate time we'll involve the children. Now, some families will say, no, I don't want my kids involved. That's fine. You've given them the option, right?
Yeah,
Some will say, oh, actually, we didn't think of that. That's a very good idea. Sometimes, of course, the children are already at the first meeting with mum and dad because they want to make sure that, you're a decent person.
yeah,
So I think generally the advice would be, or good practice might be to include them as some part of that process. But it should, I wouldn't normally look to do that up front. I would get the clients on board first and know that they're looking to put planning in place, and then at an appropriate time involve the next generation.
yeah. Someone in the comments echoed what you said about often the parents don't want the children to know. Of
Yeah, yeah. I think the key point here is giving it the option. If you can
Yeah,
get buy-in from the next generation, it will be a positive for you.
course it will.
If you don't get a buy-in, it could become a problem for you in terms of the planning you recommended for mum and dad, and it might all fall over and none of it get done. And of course, that's the absolute worst outcome for the clients because they definitely need good planning. So it's a personal choice, but that was an interesting poll. No, it's very good.
Yep, absolutely. Thank you very much. Back over to you, mate.
Okay, what's going on here? Let me just tune that on. Okay, so that moves us on nicely now to what does effective estate planning look like? So at its simplest, it's the use of relatively straightforward wills, granting powers of attorney, and the use of trusts. Now, they could be trusts created on death by the will. They could be lifetime trusts. Okay. So the framework here is the death time framework, and this is really important for me. I mean, this is the bedrock, the foundation. I mean, there's lots of cliches we could use here, I'm sure. But to get this right is really a key part of the whole process, and very important. Once that's in place, the advisors will then move to the lifetime plan. And of course, we've got various levers we can pull here for the client in terms of mitigating IHT and protecting wealth using all the options available. And of course, powers of attorney as well. And the powers of attorney, you could argue, are as important, if not more important, than the death time framework. They're traditionally done together. Okay. So that reminds me a little bit of a traditional Welsh stool. So for those on the call who are not Welsh, which is probably 99% perhaps, these Welsh stools are sturdy by design. Okay, they are valid for their stability, especially in the old kitchens where we had flagstone floors that were uneven. But they're a completely different proposition if you take one of those legs away, it falls over, right? And perhaps this is the case here. We have to look at this as a Welsh traditional stool, perhaps. So advisors have got a real opportunity here to go beyond the basic, do you have a will and when was it updated? And I would perhaps suggest that we need to get a copy of it, read it, and understand whether it's actually going to support or undermine the lifetime planning that you're looking to propose for that client. Okay. We as a company sit in the lifetime planning piece, as perhaps some of the people on the call today understand. So we're very much part of the lifetime planning, doing the heavy lifting and mitigating as much of that IHT problem as we can during lifetime. And of course, when the client dies, this is when we're going to lean back on that death time planning. And hopefully, if it's really robust and fit for purpose, it will help us, not hinder us. So the principle with consumer duty is that advisors can't ignore foreseeable risks that fall outside of their immediate technical expertise. Now, I know many advisors won't get involved with wills or LPAs. I know some perhaps set up non-reg businesses to complement what they do, and they might actually do the wills and the powers of attorney themselves. And others will refer out to specialists. So there's a good opportunity to get professional questions. Okay. So there's a good opportunity here for the advisors to meet the duty, in terms of the consumer duty principles that we got, is don't ignore it, refer it. And there's a company that we have been involved with for some time here. We've done, joint seminars together, etc. We often, refer cases to each other, and that's Kinherit. So there are lots of companies out there, but certainly Kinherit, quite local to me here. I live near Chepstow. They're Bristol based. They specialise in this area. They're, really nice people to do business with. They're very passionate about this subject matter and how they go about it. They're all step qualified. I think their mantra, actually, we've got lots of rules in our industry. So there's a 7-year rule for gifting. There's a 14-year rule for gifts. They talk about a 5-year rule in that, you should at least review the clients, or the client should review their wills every 5 years or sooner if there's a significant life event. So there's an opportunity for the advisors on the call today to help with this consumer duty part and commitment, is that if you don't have a professional connection, there's an opportunity to engage them. And I could certainly, we can share Kinherit's details if they would like to find out more about what that business does, how they can support advisors in the area of deathtime frameworks and powers of attorney. The key question is, of course, if one of your clients dies intestate or with a contested or outdated will, or perhaps loses capacity, can you evidence that you took steps to identify and mitigate that risk? So having a professional connection here is really important. It might not be your bag. You might have no appetite to get into this, but at least you can say on file, we did take a look at that will. We think, in our opinion, it's ineffective and needs reviewing. They don't have LPAs or they need to be reviewed, and just review it to that professional partner to pick up the slack. Ticking the box for the advisor then, in that they've done what they can, they've not ignored it. I'll just touch on deeds of variation. Very useful tool in the right circumstances, generally deployed when there's been some inefficient planning done. So it can be used to alter the terms of an existing will or trust. It can be used to alter the distribution of assets, perhaps add beneficiaries. It can also be used to vary an intestacy. So it's a very useful tool to be aware of. Again, this is an area where perhaps you would need a professional connection to a solicitor firm. The benefit to the client, of course, is that you delivering high quality advice. We can now perhaps introduce some protection for those assets that they received, design a more favourable tax outcome in many cases, which is often the driver when we're varying assets into trust, for example. And of course, the benefit for the advisor is that you'll be compensated for your knowledge, perhaps depending on how you go about this area of business with your professional connections. The key takeaway from this bit is that it shouldn't be relied on. It's no substitute for good planning. I get the feeling, though, with this great transfer of wealth that's upon us over the next, 30 odd years, that I know through speaking to advisors and clients that there are an awful lot of ineffective wills out there. Wills that might say, I leave everything to my surviving spouse, then to my kids, absolutely. If you've got an IHT problem, that's not really great planning. And of course, unfortunately, it means that you might be in a situation where deeds of variation are needed to correct that ineffective planning. It's also an opportunity, of course, to perhaps to look at one generation to see what's coming, to say, okay, can we advise mum and dad above your client? Are they happy to engage? Is there an opportunity to put some effective planning in place for them that might help your client? So that's all good, but I think we will see an increased use of these going forward, unfortunately. Okay, post-budget then, or post both budgets, what does it mean? I think we're all generally in agreement that it will lead to greater importance on gifting into lifetime trusts. The release have been frozen since 2009. That's now been pushed out to 2031. So that's a 22-year fiscal drag, quietly drawing more and more states into the IHT net. So we'll need to see more effective planning on first death, and generally less reliance on the spousal exemption. Now, since the introduction of the transferable nil rate ban back in 2008, we've seen a general reduction in nil rate ban planning on first death. And there's been, as a result, more reliance on the spousal exemption. Now, I think that needs to change going forward. It's not great planning for many clients. The general principle, of course, is to lock in what you can when you can, which is what used to happen with the nil rate ban trust. The solicitor would say, I want to use nil rate ban on my death in trust for the benefit of my surviving spouse and kids. That protected that chunk of money from social impacts. And of course, less transferred to the surviving spouse, which was helpful. So I think we've gone full circle. I think we'll see more use of using the allowances on first death. So this is the effective planning on first death to lock in that nil rate band. And importantly, that includes a transferable nil rate band. I do see quite a few cases whereby ineffective will fires everything to surviving spouse. No one's really looking at the numbers. Surviving spouse's estate ends up above 2.7 million, and we've accidentally tapered both residence nil rate bands away. Cost the family £140,000 in tax inefficiency. So I think it's really important that we look at these areas and review them. And of course, we're doing all that today through the lens of the consumer duty, which brings us on to our next poll question, please, Lee.
It does indeed. It does indeed. And this one is it is around, with consumer duty, focusing on the outcome for clients, how much of your planning consideration includes planning for multiple generations. And I think families want smoother transitions and less shock. I think some of the situation you might find yourself is the parents might feel comfortable with their plans, but the next generation might not know what's coming or how to manage it as well. Do you find that advisors or firms might be overestimating or underestimating the next generation of planning? Would you say, Mark?
I don't know. I don't think I'm close enough to the coalface to answer that one, really. I mean, obviously, it's very important from an estate planning perspective. That clients need to be, or advisors need to be very aware of mitigating IHT for their clients and how that might impact the next generation. And there's certainly an opportunity to get that more efficient at first generation, and there are many benefits from multiple generations going down the line then. So there's certainly an opportunity to set up these frameworks that are intergenerational, and we talk about it within Way quite a lot, actually, because our trusts have the ability to loan assets, and that's where a lot of the smart estate planning comes from, the ability to loan assets to protect them and get into intergenerational tax planning. So yeah, I think it's key that we get these good frameworks set up at the earliest opportunity that then can benefit multiple generations.
I think the tough thing about this question in particular is obviously like 60% of it is leaning towards 50% or less, right? But I suppose it does depend on the type of advisor that's answering that question. If they're not looking after the older generation of clients and they're more the younger generation, then multiple generation planning isn't going to even be coming into conversation, is it really?
Not, no. And we do tend to advise there's clients of a similar age. So I know we're an aging population, and many advisors will have clients of a similar age. So, if you're, 60, 65, maybe a bit younger, the IHT bit, intergenerational bit is quite prevalent. For those advisors dealing with younger clients, perhaps in their 30s or 40s, maybe this is less of a consideration at the moment. Other than, of course, going back up a generation to say, okay, well, has mum and dad got it sorted properly? Is their planning actually going to help you or hinder you, which is that going up a piece? So this intergenerational piece is key, really, whether that's going down or going up.
Going up. Yeah. Very fair comment there, mate, to be honest with you, very fair. Appreciate everybody that has participated in this poll. We had similar numbers complete the second as we did the first. So they are still bought in, they're still engaged, and no one's dozed off just yet. So we're going to share the results just so that everybody can see where the audience was landing. But, 62% were, 0 to 50%. So, a 60-40 divide in.
Yeah,
people fair. Exactly. I think that's fairly reasonable.
Okay,
so over to you for the last third.
Yes. And
how you doing on time? 12 minutes. Is it in the bag? Have you got it?
Yeah, we'll get it in the bag now. Okay. We are moving on to consumer duty, so I don't want to put anybody off, because I know everything surrounds consumer duties these days. But what I would like to do is just to take a focus look and unpick a few key areas, really, and consider its application and impact on estate planning, with the aim of supporting advisors to meet their obligations in this area. So it's a helpful session, hopefully. Now, we've had it for just around about 2 years now, just over 2 years, and it is a shift from rules-based to an outcomes-focused approach. We know there's 3 key elements: consumer duty principle, a new consumer duty principle, 3 cross-cutting rules, and 4 outcomes. Okay. At the heart of the principle is this principle 12: a firm must act to deliver good outcomes for retail customers. And that takes us away from the older TCF type principles to a more proactive and outcomes focused approach. And the one I want to focus on really, which is really important for estate plan, is avoidable harm. Now they come about through omissions, things we've missed, like missing, signpost in the wills and LPAs, missing the opportunity to go up and speak to mum and dad, that type of thing. And there's a danger here. I mean, it's very good of the FCA to say we must be focused on outcomes, and we'd all be on that same page. We know, yes, we've got a reasonable idea of what a good outcome looks like. What they haven't done is given us any tools to how we get there. So there is a danger here with that sort of setting, if you like, that we become outcome orientated instead of process orientated. So goal setting to have a good process instead of goal setting for the outcome will keep us process orientated. And when that process is right, the outcomes follow. Sorry, I get pop-ups here. So if you've got a good process, that'll have definition. And if you can define something, you can duplicate it. And if you can duplicate it, you get consistency. And that consistency then will help you deliver good client outcomes reliably, repeatedly, and sustainably. So this is all about getting the process right and focusing on the process. And if we get that bit right, the outcome that people want us to achieve will come. So that's the thought process behind it. And that brings us on to this elephant in the room. Now, there are lots of examples of this, and this elephant has been stood there for a long time. Estate planning hasn't changed for someone like me. Good estate planning is still good estate planning as it used to be years ago. What Consumer Duty is doing is shining a light on certain areas and saying, do you know what, we need to just give a little bit more thought around this. The simplest example I can have, and I speak to advisors at case level regularly, I sometimes invited to, review suitability letters. What we see regularly is, yes, there's a recommendation to mitigate IHT. Often that'll be 2 trusts for 325. The clients will have substantial ISAs, okay, and maybe money in the GIA, maybe other other investments. Sometimes that report includes topping up the ISA, but the file is generally silent on those other assets that are sitting in the estate growing at a 40% drag. Now, when the client comes to us and says, can you help me mitigate IHT? What they're actually saying is, can you help me pass as much of my wealth as possible to the next generation? So Consumer Duty is suggesting that we don't ignore these areas, because putting 325 into trust is one thing to mitigate it, but the top up for an ISA for clients in this scenario is perhaps, well, it's got to be questioned, really. It might still be the right thing, but did the conversation happen? So it's about broadening that conversation with the client to say, okay, yes, we can do 325 into trust and whatever else we're doing, but if we just take the ISAs as an example, you could sell down those ISAs. There's no tax consequences here. You could then loan that proceeds, it could be £500,000, £1 million, to the trustees of a loan trust. And at least now, first of all, the loan remains an asset of the client in their IHT assessable estate, but now all the growth is in the trust immediately exempt. There's great flexibility because that loan is repayable on demand. And it's a smarter IHT-centered solution here. There's no omission here, because we know if we ignore those ISAs and other assets and this client file is silent on it, excuse me, we know it's an omission that will lead to foreseeable harm. So what Consumer Duty is suggesting is we need to broaden that conversation with the client to say, look, it makes sense really to sell an ISA down. We can put it into the loan trust, get all the growth immediately exempt from IHT. You can still get your hands on it. Client might say, thanks, it's a great idea, but I just want to do those 2 trusts that we originally came to you about. And that's absolutely fine. It's almost irrelevant what the client decides to do. This is about giving a bomb-proof recommendation, and which leads to a bomb-proof client file at the end of the day. And if the client says, I only want to do the 325 trusts, you make a file note and move on. What it's done for you is given you a robust file that you can defend if questions are asked later. And that brings us on to this process, really. So again, when I sat down and designed, when an advisor comes to me, the type of information I need, I started out with a list and it kept growing. This isn't a definitive list. You can keep expanding, but we start with a Deathtime framework. Are their wills in place? Are they fit for purpose? Do they need reviewing? Do we need to refer them to our professional connection? Do they have LPAs? Importantly, are they registered? Because there's no point trying to register them once the client's lost capacity to find out there's a problem on that form. So, past and gifting history. Are there any pets or CLTs in account? Who were they to? When were they made? What was the value? I can't begin to give a recommendation unless I've got that information. So what do their beneficiaries look like? Are they UK resident? Are they, what's their tax status? Are they already high rate taxpayers? That'll give us a bit of a steer going forward. Is there a need or desire to protect assets and enhance the beneficiaries? Social impacts is huge. I mean, divorce is typically charged at 50% or worse. IHT is only 40%. We need to talk about this a little bit more. Is there a need and desire to reduce the IHT burden on future generations? How much capital have you got to work with? So this is that elephant in the room. You've got cash available. How much of their investments can you get tax efficiently, if appropriate? That helps you then with the plan. Are there any good drivers for putting more than the nil rate band? As we know, there's no limit to what you can put into trust, only tax consequences above it. Is there a need to use CLTs and PETs together in the overall plan? For wealthy clients, there often is, because there's no good drivers for exceeding the available nil rate band, so they're looking to make a PET. Question now comes to, when's the smart time to make that PET and get the tax planning optimized? Is there any surplus income? Often these clients have got lots of surplus income coming in. It's being rolled up in the estate at a 40% drag and ends up being part of that ISA recommendation that I spoke about earlier. So they're the type of questions really that should form part of a good process. The ones in red there are really important for me. I'm quite passionate about estate planning and intergenerationally. I couldn't, well, they're all important questions, but particularly the ones in red I find are sometimes not asked, and perhaps they should be, to broaden out that piece. And of course, if you want to change outcomes, which what Consumer Duty is about, it's all about driving better client outcomes, then we first need to change that process. So if we try and do a example now, it is contrived for the purpose of demonstrating, trying to pull all this together. So we've got Mr. and Mrs. Brown. They're both age 60, good life expectancy on ONS tables. They both got very healthy incomes, of which 30,000 each is surplus. We've got 2 grandchildren. We've got the assets there, house, 800,000 in deposits. They got 400,000 each in ISAs. Conveniently, their estate's worth 2.7 million, so that's a red flag. We know if we've got ineffective planning, that's going to fully taper away the residence nil rate band on second death. So they've only got 2 nil rate bands to work with. IHT liability as it sits today, 820. We could, of course, consider AIM ISAs. They only get 50% relief going forward. Importantly, they don't help us with the residence nil rate band, because the asset test for that is who owns the asset. With an AIM ISA, it'll be the individual. With a trust, it's a trustee. So that doesn't change our IHT liability, unfortunately. So what we could do, as an example, for a proposed recommendation, is they could each put £300,000 into a loan trust. Okay, they're not gifts. They could use their £30,000 worth of surplus income. That allowance is available for use with trusts. So you could give it away direct, although there are lots of reasons why we wouldn't give away assets direct. Maybe you'd want to use a trust here. And of course, then we could put 331 each possibly into relevant property trust. That's 325 available nil rate band. Often they haven't used their annual allowances, and you can sweep up 2 of them. So we'd have 325 charged at zero, £6,000 exempt transfer, make it 331. So if we put that together as a recommendation, it would immediately drop their residence nil rate band assessable estate to under 2 million. So we've fully reclaimed both residence nil rate bands. There's £40,000 worth, £140,000 worth of tax efficiency. We've had an immediate exemption to IHT on the 60 grand going in, which gives us, I think, around about 24,000. And of course, the value of the exempt transfers is 4.8. So there's immediate tax saving of £168,000 here for the clients. Given their ages, the assets is going to continue to grow. We're probably going to have to do more planning for them, because they'll soon be above that residence nil rate band. But we've got 2 loan trusts here. So what we might do in 7 years, we'd review it and say, right, you've got your nil rate bands back now. Let's review the situation, take the nil rate, the loans back out of the loan trust, and set off new chargeable lifetime transfers. And that puts a number of ticks in the Consumer Duty box, that recommendation for that client. You've looked at it in the round. The client might decide to go ahead with all of it. Often they do. We've seen that in the companies that we work closely. They often now are settling 2,325s with a sum into loan trusts, which is really important. I'll very briefly touch on gifts are a normal expenditure. Many thought that would get attacked in the budget. So this is section 21. It wasn't, which is really great. They are the rules. If the intention is regular from surplus income, it doesn't impact the standard of living of a donor, it's immediately exempt. Typically, you put surplus income on an annual basis in. It works with trusts. So you can give it away to a trust Our trust is flexible, so they can also take it back, which is really helpful. It allows them to importantly bank the residence nil rate, the immediate exemption. And of course, if you've used a flexible trust, we can pass those assets back, and then we can loan or appoint assets out as required. One of the last points, where we're using multiple trusts, of course, we're getting into the technical aspects now. We do run technical masterclasses for businesses. They're generally well received. Great for advisors who perhaps want a refresher in certain areas because they're not dealing with this week in, week out. But where we've got a recommendation for multiple trusts, it's important that we get that framework optimized. So for the purpose of this, we've assumed that there's no gifting history. So there's a clean gifting history here. We do the loan trust first. There's no gift there, so we settle the trust with whatever that is into a loan trust. Okay. Importantly, on the next day or a separate day, because we don't want to get caught by the same day additions, we would set up the trust to receive the gifts from income. Third day, we do the gift trust, so that's the 325 typically into trust. Okay, on day 3, and often these families still want to give a check to their daughter for 100,000. We do that on day 4. Okay, and the reason we do that is to optimize the tax planning for the period of charge in 10 years' time. But in order to get that right, you have to do all the heavy lifting today, which is another reason why we should consider all those trusts up front, because we can optimize the tax plan. If you're going to cherry pick and do them in the wrong order, it could be very unfavorable tax outcomes. And the reason it works is when we get to the 10th anniversary, the loan trust will have its own nil rate band, because we'll look back for chargeable transfers. There are none. It's a clean gifting history. Same with the gifts from income. We'll see the loan trust. There's no gift there, so we can ignore it. The gifts from income trust gets its nil rate band. Then day 3, we look back. We see the loan trust, we can ignore it. We'll see the gifts from income trust, but importantly, those are categorized as exempt transfers, so they do not accumulate with chargeable transfers. It means the CLT year gets its nil rate band to work with, and that's worth £19,500 per trust every 10 years, so it's not to be sniffed at. And of course, the direct pet is shortly afterwards, because we don't want to get caught by the 14-year rule in this case. So I used to tell clients, once they've done a trust, sit on their hands, don't make any further gifts. If they want to make a pet, they would do it shortly afterwards. Because if they make a pet 6.5 years after that CLT, they don't survive it. It fails. Rules say we have to look back for chargeable transfers. 6.5 years earlier, we'll see the CLT. It's dragged back into account. Tax planning disaster. So this is typically an area where we can add value to advisors. Very briefly, we do have trusts, funnily enough. We are slightly different. So we invest directly into collectives, so we are CGT accessible. We have a full loan facility, so we can get into all of this smart estate planning, protecting assets, the intergenerational piece. We hold collectives, so we don't use a bond wrapper, so we can hold assets on a number of assets with platforms, DFMs, all underpinned by our trustee service. I think the guys will get the slides, but we've got 3 legal structures. 2 are the same. We've got a flexible trust for capital, a flexible trust for income. We've got the loan trust, and we've got a equally just rebranded. It's a Section 21 trust for professional sports people. I think we've got. Could have been rushing. Have we done the last poll question, Lee? Could you run that for us now, and that'll bring us to the end?
Absolutely. Just thank you to everybody that's still with us. Mark, you've absolutely knocked this one out of the park, mate. It's been a really, really good session. Just following the session, are you more likely to discuss the elephant in the room with clients and recommend a loan trust as part of your recommendation? I'm loving the answers and the results on this poll already. We're probably sitting at about 70-80% of people saying very likely or likely.
Okay. As long as the original question before the session wasn't sat at 90, then Lee, I'm still got a job.
Yeah, absolutely. Absolutely. And the same amount of people have participated through all of the poll questions. So a big thank you to everybody that's been engaged and participated in today's session. I'll let you bring it to the end, mate, whilst other people are still answering the poll.
Okay, that's very kind. So yeah, thank you everybody for staying with us on that. I did perhaps was a bit too keen and tried to pack a little bit too much in to the session. Hopefully it's been helpful, not least in helping you with the consumer duty aspirations. As a business, we are a little bit different to other providers in the market. John and I are very happy to get involved at case level. pass comment on what you're thinking along the lines of, suggest improvements to the planning, perhaps to optimize the tax planning. We will quite happy to attend client meetings with you, generally support you in whichever way you would like support, whether that's to review your processes or the technical side. So, please do reach out to us if you would like further information on that.
That's amazing.
Okay.
Amazing.
Yeah. Okay.
There we go. I will share the results of the final poll for everybody to see. 34% very likely, 63% said likely. So the poll results went in a good direction towards the end. Over 100 people still with us. So please do, if you have got 5-10 minutes to hang around, please do ask any questions. I know we've had quite a few questions coming on the other side of things. There was one particular question that I want to bring up with you, Mark. What was the diplomatic phrase Mark used to talk about family conflict?
Oh, I don't know. I can't remember now. did they use a diplomatic phrase? Did they? How posh is that? Valley boy and all.
John, I don't know if you picked up that phrase at all, and you're open to unmuting yourself and bringing it to the audience.
What was the subject matter about family conflict?
Yeah, family conflict.
Yeah. Simon picked it up, and I've got to be honest, I didn't pick it up either. So well, I was going to ask Mark what it was.
We've all got enough AI running these days. I'm sure we'll be able to pick it up what you said somewhere along the line. But we've had some good questions about the way inherited loan trusts having a 7-year qualifying period. We've had some really good questions coming in.
Okay. Have they been answered?
They have. John has been all over it, and he's been answering all the questions in the background. So well done, John, for picking those up. So if anybody does have any final questions, please do fire away, because you can hear it from Mark and John as they communicate live with you instead of over text or message. If not, thank you again for joining us at the Financial Planning Club, for joining Mark, John at Way Trustees. I'm sure you'll all have, and we will wish you a wonderful Christmas and a happy New Year. And hopefully you come along to future webinars. As always, please do complete the feedback form when you exit today's webinar. I'd love to hear your thoughts on Mark and the presentation that he ran today. Any ways that we can evolve and adapt our sessions to make it better and more impactful for you is of interest to us. So please do share your feedback. Still, guys, thank you very much. Have you got any other content being delivered for the rest of the year?
No, I think generally now, I think in terms of seminars and presentations, that's it for us for this year. But we've been busy setting up a schedule of events for next year, which we'll hopefully see advisors on. And
good.
We'll continue talking all things smart estate planning, hopefully.
Yeah, absolutely. Talk to me briefly just about these masterclasses, Mark, and what they involve. Is it a whole day thing for the firms, the advisors?
No, it's probably a minimum of, about an hour and a half, I would say. We tend to run them on a one-to-one basis. So we'll go into a firm, they'll have their advisors, planners there. And it's just a refresher, really, on certain areas that perhaps are a little bit alien if you're not using them routinely. I mean, we touched briefly in this seminar on order of gifting. I mean, it's key, really. And again, it's something that should be noted on file and that you've considered it and got it right, or done something otherwise. I mean, the general principle with the FCA, of course, if you're subject to a review, if it's not on file, it didn't happen.
Yeah.
So we go into these firms and work with them, talk about order of gifting, taper relief, period of charge planning. Again, that's quite an area where we can make quite a difference. We talk about good processes. I mean, I am quite a process-driven person, and I think processes are key. As most businesses will understand that. But again, a poor process can lead to poor outcomes. So it's just fine-tuning those processes to make sure we get the right questions asked. That helps give a steer to the planning. That then helps you bring about your recommendation to the client with consumer duty in mind, fully, the wider piece. And as I said before, it's almost irrelevant then what the client decides to do, really. You've done your bit. They will decide what they proceed with, and you make a note on file, and everyone's happy. So these sessions can really help deliver better recommendations to the client, ultimately. I mean, that's what they're designed to do, and just refresh that knowledge and put it into practical application. We don't then, because it is a case really of you can fall into some traps if you're not aware of them. It's that saying, isn't it? You don't know what you don't know, or might have forgotten. So those little nuances, and there's lots of nuances that we've brought about. 91 changes to the tax code in that budget. So it's a minefield for advisors. I mean, I'm glad I'm not an advisor these days. I only have to concentrate on one area, and that's enough of a challenge, if I'm honest.
Yeah.
To think of these advisors now, particularly with the pension piece, I mean, that's it's significant, and there's a lot pushed onto these advisors. Consumer duty being one of them. I think, generally, personally, it's a good thing. It's certainly helped us as a business, and me and John talk about the things we've always talked about, but it carries a little bit more weight now because Consumer Duty have suggested that maybe we should be, improving our game in certain areas, and it's allowing us to talk about that. And hopefully that came across in today's session about how we approach estate planning with the client to look at that wider piece, and make sure we're meeting our obligations under Consumer Duty really. And the professional connections has been talked about quite a bit in the industry for a number of years now. The importance of them, having the right people doing the right job. I mean, that's a very basic thing at a basic business level. You want people in your business, the right people doing the right jobs for your business. Well, it's exactly the same in estate planning really. Professional trustees, we've seen a huge increase in demand for professional trustees. The compliance burden in this area is now significant. If families want to have their children involved, my advice to advisors today is if we can keep family members out from being professional trustees, that's a good starting point, because they fall out, they disagree, they won't fill out paperwork in a timely manner. Sometimes they go and live abroad, and that brings all different set of risks to the trust piece, because, of course, if we've got one UK trustee and one overseas trustee and the UK trustee dies, that's unfavourable from a tax perspective. So having professionals doing the professional trustee piece, trust specialists helping advisors with the trust piece and IHT, and it's very much a niche area. Having those professional connections for wills and LPAs, firms like Kinherit, just helps people deliver better outcomes and stay on the right side of the compliance when it comes to Consumer Duty and that.
Absolutely.
It's a good thing in the main.
Yeah, definitely. Look, we've still got just under 100 people hanging around. So this is where I usually just waffle on for a little bit until people fizzle out. So just for the purpose of the people that are still with us, the content for today, in case everyone's thinking, God, when's this going to come to an end? It has come to an end. This is where I'll just talk with Mark and John, just why everybody fizzles out. But you spoke about attending client meetings, with advisors to provide that additional support. As you said, bring the expert into the room. Talk to me about that. What's that process like? How does it, benefit the client and help the advisor?
Yeah, I've got a number of accounts that need that extra technical support. I wouldn't say I'm unique, but I do have the benefit of being an IFA for many years, quite active in this area. So I was familiar with it as an advisor. I understand what the advisor piece is. I've now specialized in this area for 12, 15 years. And my role now is basically to support advisors with the practical application of that legislation. Sometimes that means I go along to client meetings because, yes, the advisors are well aware, but there's sometimes that element of doubt, and often it can be helpful in a client setting. And I had one not that long ago where I met the client. The advisor had already done the heavy lifting, really, but thought it was appropriate to invite me along at this stage, just so the client could ask any other questions and to make sure that he could get those answers. And that often gives the client a lot of reassurance, actually, that they're looking at Mr. Way. I mean, I'm representing Way at that point in time, so I'm a face to that organisation that they're considering giving, in some couples, £1 million or more, perhaps, if we're using multiple trusts. So it's important to them. They know who they're dealing with. Am I normal or have I got two heads? And of course, answering those questions can be very helpful to that general advice piece, because often it'll be the last link in getting that piece over the line. And I find that in many cases, that the advisor then is in a position the client, there might be another follow-up after my meeting, but generally that meeting is, yeah, I'm happy, let's do this. And it can help, make sure the client's really happy, and that's the key thing, and they understand it, and get the business over the line. And again, clients here can be different. I had some clients that are super technical. They want to know everything, and it's a real mental workout. And they're asking me things, and I'm thinking it's in there somewhere. It'll come out in a minute,
Yeah.
And I'm hoping it's not going to be like that Morecambe and Wise. All the right words are there, but whether they come out in the right order, I don't know. So some really want to drill down, and that's fine. If that's important to the client, that's exactly what we give. I mean, I generally try and steer clients away from the technical piece.
Yeah.
The advisor and myself need to know it and understand it. Generally, I would present, and when I was advising, I would present a relatively high level. Yes, they need to understand how it works, but they don't need to know
the ins and outs. Yeah.
No, they don't need to know how the change to Section 69, which is now effectively abolished, how is that going to impact them?
Yeah.
Too much detail can switch them off, for sure.
Absolutely.
As it can switch off many advisors on presentations.
Sometimes it could probably be all a bit too confusing and maybe even put them off, let alone switch them off. It could be, well, I don't know, that seems a bit too complex for me and for my liking.
Yeah, exactly that.
Okay, so let's bring things to an end. If anybody wants to get in contact with anybody at Way Trustees, all of the contact details for Nathan, Mark, and John are below. Please do complete your feedback form. We will send you an email after today's session, probably early afternoon, where you can revisit and rewatch the webinar at any time on our YouTube channel. We'll also send you a link to fill out to complete your CPD form and receive your certificate as well. So from everybody at the club, have a wonderful Christmas and New Year, and likewise from Way Trustees. John, I know we've got a meeting on the other side, so thank you very much for presenting for us today.
It's a pleasure, Lee. See you soon.
See you soon.